Just a quick reminder, the microphones are directional, so if you're in front of it, it'll pick you up. If you move off to the side, even though you're the same distance away, nothing's there. So keep it right in front of you, please.
Go ahead and start.
Allegiance to the flag, United States of America, to the republic for which it stands, indivisible.
Ready to start with roll call?
Committee Member Gorley,
Here.
Committee Member Parker,
Here.
Committee Member Reynolds,
Here.
Committee Member Yan,
Here.
Vice Chair Jarvis,
Here.
Chair Thorstead.
Here. Before we start, just for the record, Councillor Bronson brought up a subject that he wanted us to address. And chapter 4, page 3, the line that says 30 days out of the city, he believes that it's not relevant and it should be removed. So I just wanted to bring that up to everybody and we can discuss it. In this page, chapter 4, page 3, so right up here, subsection 1A.
Okay, we'll bring that up in the
Yeah.
general charter review.
So, just for the record, we're going to start.
Minutes.
Minutes, yes, we need to approve the minutes. Do you want to make a motion?
I move that we accept the minutes as presented.
I'll
Second.
second. All those in favor say aye.
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 Any opposed? Thank you. We have no public comment. So we'll just go ahead and move straight on to old business. We're going to start kind of in the middle and then we'll go back to the general discussion. So you're going to have two packets in front of you today. The one that has the agenda on top is obviously the agenda packet. The one with the charter proposed that is separate, that has a few additional comments from City Attorney Larson, including on page 6 at the top, section 5.8. That is the language that he has proposed for that placeholder for due process and enforcement related to the ethics code. So if we could have a discussion on that section and language.
Any discussion?
If I may, this is section 5.8, right? New section
Yes.
5.8. The council shall be the judge of the election and qualifications of its members. Could you clarify what your intent is with that, Blair?
So that essentially when there's any allegation of whether somebody is qualified for the office, that's most likely to come up when determining residency or discussing residency. And essentially, it just puts it in the lap of the council of determining or hearing evidence as to whether that's in fact the person does live in town or whatever. That's just an example. It doesn't focus necessarily only on residency, but whenever any question like that comes up, it's up to the council
is
to discuss that.
What it's doing then is it's establishing the authority.
Right.
Yeah, I like that.
Well, I have a question though. Does the council have the authority to remove someone that's been publicly elected to office? They can sanction them, they can call it to question and turn them into the ethics commission, but do they actually have the authority to legally remove somebody from office?
If it's very clearly laid out in the charter that they have that authority, and if they are afforded due process, then there's not a lot of case law on this, but it is my opinion that if they're afforded due process and it's a clear violation of what the people of Sweet Home have voted for, then yes, that is legally binding.
And I think they should outline what that due process would be.
So
it
that
is
is
consistently applied.
so that's one I thought about putting a lot more meat in this when it came to that due process, but it's very unusual for a charter to go into depth. Essentially, what needs to happen is people need to be afforded an opportunity to hear what they're accused of and to defend themselves, and they have to have adequate notice that they can prepare to refute those allegations. Now, certainly you could put in all sorts of rules in there for a process, and that's I think that's certainly up to you. I didn't really want to overstep and go into too much into that. It's not something that I've found really in any other charter. In my research, I haven't found an example of a very clearly laid out process. It's essentially what typically seems to be the case is that charters will outline that something like this, that that gives the authority to the council to decide such matters and insists on a public hearing, and then when it comes to any of the details, it punts it over to the council rules for the council rules to determine how that's handled.
Also, I believe that the county clerk, prior to the election, verifies address with DMV, so like this. So there is a step that happens prior to the election. So
Correct.
if it gets missed, then you gotta deal with it.
But if you have a case where someone moves out of town in midterm
Yeah.
and doesn't resign, and is, then it would be a matter for the council rather than the county.
Yeah. Right.
And so it would be the county clerk that investigated this to.
Well,
prior to the election.
if it's prior to the election, because and Cecily, correct me if I'm wrong, but if someone is running for office, they first register with the city that they're running for office, and then it also goes to the county after that. So there's several eyes on matters like that.
I know this has been an important topic for our community, and I'm not opposed to the idea. I just want to make sure that if we have language that it's not something that can be, that is in keeping with the law, and that the process is clean.
The issues that I've come up with or that I've seen that have arisen, and we can talk about this later also when with the interference with an administration aspect. There was a recent case with the city of Corvallis and a counselor who was basically removed from office for interfering with operations of the city manager. At least that was the claim. Ultimately, that went to a federal district court, and it was found that that was an infringement on free speech. And so we can talk about the barriers there, but that's the most recent example in Oregon of a counselor being removed. And the main issue wasn't a due process matter. That didn't come up in the case law at all. The discussion was mostly about free speech. So due process was the part that was fine. It was the fact that this was essentially punishing speech rather than any actions.
If I may, the one thing that I have a little bit of heartburn over is the rules established by by the council. I think that there should be a really, really high threshold, you know, as we've spoken about before, in order to remove somebody from office. You know, for the council to be able to do that. And so I like the language up to that rules adopted by council, because council could, not saying that they have ever or that they necessarily would, but they could, through establishing rules, they could establish some rules that are pretty onerous for someone to live up to if they were targeting a specific individual. And therefore, they could use this language as a means to an end to dispose of someone that they personally don't want on council. So I think that the threshold should actually be rules of the charter as opposed to rules of the council.
I would actually disagree with Mr. Jarvis on that one. I think it's great the way it's written, and this whole thing, of course, was because I brought this before the committee, this whole section 5.7. And on subsection B, it talks about the council shall by ordinance enact the code of ethics applicable to the mayor and to the council. And I think the same thing could apply on this last part. Same concept like you're proposing here at the council, figure out what the rules need to be for due process and all this business. I just think the charter needs to be a little on the broad side and just gives the council authority to deal with ethics issues and whatnot, and not get into the nitty gritty and all those details.
And just as a historical reminder, one of the questions that has come up over and over and over is that there are no teeth to enforce the council rules. So I think this language is the attempt to correct for that in the charter.
Right.
Since right now the rules are kind of circular and self-reinforcing in a way that doesn't give them much power.
I would say that as the rules stand right now, I haven't seen anything in the rules that alarms me when it comes to something that could be unlawfully done against one of the council. Now they are, of course, free to change those rules, and that's something that they would need to look at. And the rules really should be changed on a regular basis to keep up with changes. As those are changed, I would hope that a legal opinion was given as to any of those changes to remind them, well, if you exclude somebody or if you remove somebody for this particular reason, you're going to run into trouble with an appeal. You're basically asking for a court fight in that. So I think that I share the concern. I think that there are opportunities to keep that from happening in the existing system as well.
Well, that's my main issue, is just to make sure that there is some form of built-in, and as you mentioned, we do have a city attorney, you know, that can advise that.
Not that I'm super wonderful,
but still to avoid arbitrary and capricious type of rules that are established to target an individual. You know, as long as that's possible, I'm squeamish about it, I guess is what it is. But, you know, hearing that explanation, I am a little more satisfied.
And one more thing, you may have noticed, I pulled this out of that 5.7 and I put it as its own section 5.8. And that was mainly to make it clear that this is talking about violations of the entire charter and not just that specific ethics portion.
Because I thought, according to law, that you had to live in the city that you represented, just like you have to live in the county or the state, and that there was already an enforcement mechanism for that.
Well, it's true that it's the law. As for the enforcement mechanism, that's the question. It's a squirrely issue trying to pin down residency. And a lot of people are very good at claiming residency in one place that other people will look at and say, no, you're not actually a resident. it's not as clear cut an issue. For most people, they only have one home, and you can point to that home and say that's where you live, and there you go. That is your residency. There are some folks that have more than one home, or they have a home in one place and a rented apartment in another place for business purposes or tax purposes or who knows what. There's all sorts of reasons somebody might be in that situation. And that's when it gets a little bit difficult for to really enforce on the residency issue. So I certainly would express caution. I don't think there's anything that we can put in the charter that's going to make that easier, because it would likely be struck down as unconstitutional. But it's something certainly to keep in mind, that even though you put a rule in, it doesn't necessarily make it enforceable in all the cases you think it should be enforceable in.
Yeah, and I'm not opposed to the idea whatsoever, but I also, I think maybe steps of not particularly regarding residency, but ethics, that the mechanism of being able to censure somebody, being able to recognize publicly that there's a problem before they're removed, so they have the ability to rectify. At some point, being able to address those before you go straight to removing them from office.
Sure.
Some language that would add that step, right? Because public censure is pretty serious and people take notice of that. And most people will clean up their act. I recognize not everybody will. But in regards to their general ethics, it's might be something we would consider.
I thought about putting that in here as well. And then noting that it was in the council rules already. It just seemed that that was the easier path, was to have that structure in place there. Now, it is an option, of course, to pull over a process like that into the charter itself. It's just a question of whether you think that's the appropriate place for it. Obviously, the benefits of it being in the charter is the council can't change it on their own, which is good and bad depending on which side you're on. But certainly that's something that if the committee would like to have included, we can look at some options for that.
I don't know. I think certainly anybody who's going to complain if they get censured or come up to be possibly removed from office, they're not going to like any of it. But anyway, I'll go with what everybody else wants to do.
Any other discussion? We're gonna need a vote on this.
Well, we're gonna need a motion first.
That's what I'm saying.
Oh, yeah.
Need a motion.
I'm still not sure that I wouldn't want to amend it on one thing, but I don't want to overcomplicate it either. So just for the sake of getting it on the floor, I make a motion that we adopt the section 5.8 enforcement that has been presented and recommended by Blair Larson.
I'll second.
Any discussion?
I would like somewhere in there to say any counselor charged with conduct constituting grounds for discipline or for removal. That way we include a form of discipline that is without just specifying removal, so that it does make clear that there are other avenues before we go to the guillotine, as it were.
Doesn't it say that though, where it says end of any disciplinary action of its members for violations of the charter?
No, that just indicates
that
that
not
the
covered?
council is the judge of it, that they're the
Okay.
authority. So the that last sentence in there, any counselor charged with conduct constituting grounds for removal from office shall be entitled to a public hearing with public notice of such hearing given at least 1 week in advance of the hearing. That's kind of a self-contained and would only apply to someone who is in danger of being removed from
Okay.
office. So if you want to include that for any discipline, there are in the council rules, I think there are 3 levels of discipline. There's a reprimand, a public censure, and then there's finally removal from office. So there's one that's kind of a slap on the wrist. There's one that's more public and a stronger slap on the wrist, and then there's finally the removal. So my question then is, if you want it to have make sure there's a public hearing for those other things, do you want all discipline, or is there some level of discipline you
Well,
think the
are
council
we
can
not-
do on their own without a public hearing?
Are we not presuming that any discipline would be at the discretion of the council in the first place? And we have no discipline spelled out in the rules already, but we are addressing removal.
No, we do have, there is, in the current council rules, there is discipline spelled out.
There is discipline spelled out?
Mhm.
Okay, lacking that, I will withdraw my amendment, and it essentially died for lack of a second because we discussed it before we ever got to that anyway.
So there's a motion.
A motion with the amendment that I would like.
The amendment would die without a
Yeah,
second.
right. But that's what I'm saying. We were discussing it
Sure.
before it received a second, so I will withdraw it and call it dead.
Any other discussion? Guess we need a vote.
I'll do roll call on this one. Committee Member Gorley,
Yes.
Committee Member Parker,
Yes.
Committee Member Reynolds,
Yes.
Committee Member Young,
Yes.
Vice Chair Jarvis,
Yes.
Chair Thorstad.
Yes.
Motion carries. Okay, so now we'll start fresh from the top of the packet. Most of the items you'll see in here, and again, this is the one that's the charter proposed by itself because there were a few changes from what was published in the packet. Most of that is going to be comments or corrections or suggestions from City Attorney Larson. You'll see section 2, I had misnumbered, so thank you, Vice Chair Jarvis, for pointing that out. So for discussion purposes, we will start with new section 3.1 regulation of elections. You'll see City Attorney Larson's comment regarding residency, which we kind of addressed already. So he has some suggested amendments to the language there.
Yes. So generally in law, if you have a residency requirement that's greater than 1 year at the local level, most courts have struck those down as unconstitutional. Now, this is not exactly more than 1 year. It sort of is, but it's just close enough to the edge that personally, I think it's a more legally defensible position to be in if you just have the determination of the day of the election as being that year residency date, rather than the beginning of the filing period as was discussed. And so, but if you want to keep it your same, I don't know that it's a huge problem. I think that it's something that will be more legally defensible, but also more clear to the general public. People know when election day is. People don't know when the only people who do know when the filing deadline is are the people who are running for office and the people who take in those applications. And so to the average citizen, they're going to be like, well, yeah, why can't that person run? I know that they've lived here for a year before election day.
Well, I move we adopt these changes in the other one down below, and there's seek office as well.
I second it.
Any further discussion? All those in favor say aye.
Aye.
Any opposed? Okay, so moving on to page 3, I'm sorry, section 4.1B, this is to go back to Counselor Bronson's comment. It currently states an appointed office shall be deemed vacant upon the incumbent's death, insanity, conviction of a felony, resignation, absence from the city for a period of 30 days. Oh, and I see it's referenced in section A as well.
Yeah.
Without the consent of council or upon the incumbent ceasing to possess the qualifications necessary for office. So this is basically defining vacancies. So he was wanting to remove just the section related to an absence for 30 days.
Yeah. We can have a discussion about that.
Yeah, I guess my only comment from staff is you can gain council's consent, which essentially functions as an excused
Right.
absence. So
Yeah.
I guess what it comes down to is should a counselor need to seek permission from the rest of the council to go on a long trip?
I don't know that that is necessarily seeking permission so much as it is providing some form of notification, which one would hope that all counselors would do.
Right.
Live in the day of, so Zoom meetings and things like that. So a person isn't just MIA, if they're gone or work or something for a month.
This did come up recently in one of the counselors' questions to me, and this counselor was looking at a professional opportunity to be gone for an extended period of time, and didn't want to resign the council seat because it was unclear how long of a professional obligation this would be. But it was a seasonal matter, not likely to be more than 6 months, but could have been up to 6 months. So, and it also, it was erratic. And so it wasn't clear which meetings would be, that counselor would be available to attend. And I explained this provision and essentially said, you're going to need to, you certainly can do it. You just are going to need to be excused by the council for that matter. So that's, I think, the real world most extreme case that I know of is somebody possibly being gone that long for work purposes. But it's up to, I guess the Mr. Councilor Bronson, I know, takes some rather extended trips for some of his personal activities. And I think my impression was he didn't care to ask approval for any of that.
Well,
But
isn't there a difference between being gone for 30 days or taking up temporary residence for a job? That's markedly different.
well, this job, it wasn't taking up residency anywhere. It was traveling. There wasn't one particular spot. So it's, there are folks who travel for work, but usually come back to the same home base, and they're not necessarily in any one location long enough to establish a residency. I think there are cases where that would probably be fine and wouldn't violate the charter, but it's this extended absence business that is the issue of, like staff said, that, they can just go to the council and seek it to be excused, and hopefully everybody would be reasonable about it. The question is, should we continue with with that method of doing things, or is there any reason to change?
I think that the intent of it mostly is, for the notification, the customary and reasonable, what a reasonable person would do, which is provide notification. But if there is concern about that from a sitting council member, we could always put parenthetically in there, either with the 30 or the 60 days that, and put parenthetically, and request for such would not be, cannot be unreasonably denied. Something like that. That would probably add some comfort, but I like having the language in there because it establishes if someone just simply is absent, they've disappeared off the face of the earth and don't seem to wish to communicate. I think that's the purpose of that language being there. So I think such request shall not be unreasonably denied will cover that concern.
I agree.
And so I put that in the form of a motion.
Is that, sorry, is that to add language to it?
Add language.
Okay.
As opposed to, as opposed to removing language.
Well, then in that case, should it also state that it's for a period of more than 30 days?
Point of order, we really need to second the motion before we discuss it.
Yeah, we need a second.
I'll second.
Okay, any discussion?
Yeah, should it then say for a period of more than 30 days and not a specific 30 days? What if you're gone 31? I mean, if you want to nitpick it.
Okay, I would accept, I would like to offer a friendly amendment, if this could be accepted as a friendly amendment, to change it for a period of 30 days or more.
Yeah.
Without consent of the council, which shall not be unreasonably denied.
There was mention of the 60 days as well. Would there be that same clause added in that portion as well? Or are you talking, you
Or
are
we could actually delete that if we had the 30 days or more. Because
Well,
that would encompass that.
No, the 30 days or the 30 days is absence from the city.
Oh,
The
okay.
60 days is absence from meetings. So the difference being 30 day, you know, if you're on a vacation for 30 days, that would be the first one. If you're in town, but you've just missed meetings
I think,
without being excused.
I think what we should do, what I would like to see us do is act on my motion as it was stated, and then deal with this as a separate issue, which now that you've made that comment, I think that maybe being that we've already covered absences elsewhere, that pending the acceptance, you know, and in the charter of that, we would no longer need the 60 days.
But we're also, I think, talking about two different things.
Yeah, so I guess discuss the first one first and we'll
Right.
deal with the 60 days later.
Because
So
the intent is that one person just disappears and the council can't get a
Right.
hold of the person. That's what we need to deal with. I think if somebody's going to miss more than 30 days, they're going to let somebody know that they're going to be gone for 30 days. And then the council can address that due to the rules. Right?
Correct.
So I think we're talking about two different things here.
The 30 versus the 60. Yeah, I agree.
I'm just curious what unreasonably denied means.
Well, that's open to interpretation, but once again, the reasonable person. I mean, how many times do we in any legal process, you know, use the reasonable person model? That, you know, that it's not going to be arbitrary and capricious, which is usually pretty clear to people.
I guess
What is reasonable and what's not reasonable.
I could just see, for example, you know, in the scenario that we had, if a person asks for 3 periods of 30 days of absence related to professional opportunity, and then another person asks for a period of 30 days for personal reasons, technically the second person is going to be absent from their office less, but maybe council feels that personal reasons are less justified. So if they deny the lesser absence based on the reason, I guess that's where I find it a little sticky. If they don't think your reason is good enough versus we're just going to hold a 30-day period as the standard. And you know what I mean?
Oh, yeah, I do know what you mean, but I'm not sure that we can, I'm not sure that we can pin exactly what we want in order to accomplish that. I think mostly what we're doing here is trying to satisfy someone who fears that taking a 30-day vacation is going to make their office be declared vacant. And this still, you know, it keeps the 30 days in there because I think it's important to have some language in there on both the 30 and the 60. But this kind of clarifies that it's not really that big a deal. The reasonable city council will say, sure, see you in 35 days.
I would think that a council, especially in a public, which all the meetings that they have to be open to the public, and you're going to have members of the public coming, that if there is a counselor that feels people might be unreasonable, that there would be others in public that would notice or it would be mentioned. Certainly if that counselor is removed from office, it's going to be publicized to some degree. And I would think that there would be a general outcry from at least some citizens that, hey, somebody we voted for has been removed from office for a reason that we think is that yes, it satisfied the letter of the law, but it was completely unreasonable to withhold that excuse. I would hope that all the council would be thinking about that possibility because we have enough furor over really minor things. Somebody being removed from office is going to bring up a lot. So I question, I guess, that's a rambling way of saying I question whether it's really necessary to put some clause to make people feel better when the thing that actually has the teeth is going to be people getting angry and residents voicing their desires.
I pretty much agree. I don't think this part needs changed at all. So.
Any other discussion?
I agree with Committee Member Reynolds. I mean, the only thing I'd like to see is just the addition of 30 days or more, or for a period more than 30 days. I think any other added language isn't necessary.
Okay, so if there's no further discussion, we'll take a vote on the motion, which, just to clarify, would be to add language that a counselor's request for absence for the 30-day period only shall not be unreasonably denied. So if you vote yes, it is to accept both of those changes. So I'll do roll call again. Committee Member Parker?
No.
Committee Member Reynolds?
No.
Committee Member Yan?
No.
Vice Chair Jarvis?
No.
Chair Thorstad?
No.
Committee Member Gorley?
No.
Motion fails.
So we need to make a new motion.
Correct. So Committee Member Parker, if you want to
Okay.
revive the 30-day.
All right. So I would make a motion to add the language of a period of more than 30 days or a period not to, exceed 30 days. However, Blair might
Cool.
feel
Are you saying that you want to make sure that anything past 30 days is included?
right.
Okay, so you would want to say 30 days or more.
Correct.
Need a second.
Second.
Any discussion? No discussion. Roll call.
Committee Member Reynolds?
Yes.
Committee Member Yan?
Yes.
Vice Chair Jarvis?
Yes.
Chair Thorstad?
Yes.
Committee Member Gorley?
Yes.
Committee Member Parker?
Yes.
All right, motion carries. So now I think we want to visit the 60-day question, which is at the end of 4.1A.
I think, as it's stated, with 60 days without the consent of the council. I think the council, if it's a respectful absence, the council would approve it. So I think it should stay.
Agreed.
I agree with that.
Okay, so barring a motion, we're just going to leave that
Yep.
alone and move on. In section 4.2A, just thank you, Vice Chair Jarvis. In the middle there, you'll see we added or mayoral to clarify it applies to the election of either a counselor or the mayor. And then in section 4.2B, City Attorney Larson pointed out that the original wording was a little bit confusing. So it sounded like the council would have to wait 60 days before they could fill the vacancy. So I changed the language to specify that it has to be filled within 60 days. Is there any discussion on either of those points? Okay. Okay, and then on the next page, section D, City Attorney Larson had a comment about that final sentence and whether it's necessary or not. So feel free to discuss. His comment is that it seemed circular, since the city manager is already stated to have the power to fill vacancies. Do we need to call out temporary vacancies separately?
Any discussion?
So this is all in the purview of the city manager now, so it seemed like it's not needed.
Yeah, the only thing that might, but I don't even know that that's necessary, would be offices filled by appointment and then a comma, including temporary appointments. But I don't even think that's necessary because we're just dealing with vacancies. If it's vacant, it's vacant, temporarily or otherwise. So yeah, I think deleting that language would be good.
I move we delete that last sentence.
I'll
Second, third.
All those in favor say aye.
Aye.
Any opposed? All right.
Can we go back to 4.2B? As it, in my copy here, it says vacancies in elected offices filled by, vacancies in elected offices that occur within the second half of the elected term shall be filled by appointment by the city council no later than 60 calendar days from the time the vacancy occurs. Is that, the way I read that, is that the correct version? Or the current?
Yeah, let me
That's what we
pull up
listed
your
there.
note.
Because my concern is this is essentially saying, council, you have 60 days from the time this seat becomes vacant to appoint somebody to it.
That's what I thought your note was saying. You wanted it to say.
I was saying the opposite.
Okay.
I was saying that's what the language said, and I'm concerned about that because it essentially, you could argue that if you wait too long, then the council no longer has the authority and you have to have a special election to fill that seat. It just, the way it's written is a little bit confusing to me, and maybe I'm the
Okay.
only one.
So the original language said, well, the proposed new language originally said, vacancies in elected offices that occur within the second half of the elected term shall be filled by appointment by the city council within no less than 60 calendar days from the time the vacancy occurs. Your comment on that was, does this mean that the council must wait at least 60 days before appointing someone to fill the vacancy? That's what this says. So this is language I changed it to, but we can certainly change it again.
Because this still makes it sound like they have to act within that 60 days.
That was our
Whereas-
intent.
That was the intent.
That was our
Oh,
intent.
it was, okay.
Yeah,
if that's
yeah.
the
It was
intention-
that they not
So
sit
what
on their
happens
hands.
if they don't, I guess is the question.
Well, maybe someone could make the argument for what you just argued.
Then, I mean, do you want, I guess that's the question is if they have to, if they have to do something within a certain amount of time, there's always the question of what happens to them or what happens to the seat if they fail to do so.
I guess that was the test. The whole idea was just to make sure that we don't sit on our hands, that we actually make an effort to get the thing filled
Yeah.
as quickly as possible.
I guess my concern would be that right now, when a vacancy does arise, typically the council asks the staff to advertise the vacancy and seek applications from residents who are interested in serving on the council. That process, and usually you want to give people at least a couple of weeks, but I think I'm not sure what we've done in the past. Has it been 30 days for
I
people
don't
to
know.
respond, to actually put their hat in the ring? And then at that point, there is a committee that reviews the applications and interviews the people. And then it's brought to the council for appointment. So that whole process, depending on how much time you want to give residents to respond to an advertisement that there's a vacancy, if you give them 30 days, which I think is reasonable, especially given us not having everybody gets their news in different ways. And so a lot of people aren't going to know about it at first. But if you give them 30 days to respond, then that gives the city only 30 days to go through those applications and then for the council to appoint somebody. So I'm just saying, I can see why it would take longer than, I can understand the desire to have it be, don't sit on your hands, but I can also see the council having trouble
That may,
filling it fast. 'Cause you don't want to do it too quick, because then you got a bunch of people in town who might have been interested in serving on the council and they never heard anything about it because your application window was too short.
that is, that point is well taken. Yeah, that may be what we want to do is say within 90 days. But I have a question for Lisa. What is your recollection of your experiences, Lisa? Because you were on council when we had some vacancies in the past. And how long did it take you guys to select a new city council member?
I think it takes time, but I think that if you give 90 days, they'll take 90 days. If you give 120 days, they will take 120 days. That there is an expediency, and that because of social media, because of the newspaper and all the avenues we have, that word gets out pretty fast. And so I'm not opposed to the 60 days. That's 2 months out of 12.
So if we think about it, we have a vacancy, we give 30 days to advertise, then city has to get the admin and finance committee together. We interview everybody and then we notify. So there's a scheduling thing of 2 weeks. And then we vote right on it. So realistically, in 60 days, it could happen.
So is there council rules on how long seats open advertised?
I don't
I
believe
don't
so.
believe there's any rule right now. And this is just my own opinion, and so take it for what it's worth. If that's what you intended, by all means continue with that language.
Somebody's going to step forward. Somebody will step forward.
Especially when there was like 17 that ran last time. But I think, 60 days, I think it could be done.
And remember, council has a chance to change this anyway, so,
It's true.
or reject it.
So we're all good with 60 days?
I am.
Consensus? Yeah.
Yes.
Okay, so then moving on to page 4, section 5.4, Council President, City Attorney Larson asked, does the mayor vote in the election of council president?
We have not removed the mayor from the body of city council. And so I would say yes.
Is there any desire to specifically call the mayor out so that it can't be questioned? I think that was the intent of the question.
And it's perfectly fine if that's the way you see it. It just occurred to me as I was reviewing it. Oh, that's the mayor is everything else points to the mayor voting as a counselor. And so,
Yeah, and I appreciate the fact that you do ask these questions of that. But but from my standpoint, I am satisfied that yes, that we have established that the mayor is part of city council, and accordingly, I am good with the mayor voting for president.
Yeah, I remember having this discussion because like City of Lebanon, the mayor does not vote. It just coordinates the meetings. So, and we talked about it and everybody thought that the mayor should have a vote. So
the main reason it occurred to me is if you look at the language, the council shall elect from its membership. And so it is if you're comfortable with the mayor voting in that, I think it merits having something that specifies that the mayor is allowed to vote for it, because when it talks, the council shall elect from its membership, so it can't be the mayor because it's got to be a member of the council, but the council is electing that, so I'm not sure how to word it, but I guess I can see people being confused by it because I'm confused by it.
But is the mayor a member of the council?
So the mayor
Person just
is,
elected separately.
this is recently changed. So before, the mayor would have been a member of the council, would have been from among the council, and it would have been clear that the mayor could vote for this position. Now that the mayor is elected separately, then there is the clause that says the mayor votes as a councilor, which then would make somebody think, then the mayor should be able to vote for the council president. It's just that the language specifies the membership of the council rather than it's kind of I'm talking myself in circles. Sorry. It just is a little bit confusing to, I want to make sure that it's clear to people who's voting for what.
Well, it says the mayor shall be the chairperson of the council and shall preside over its deliberations. I think it's really pretty clear that they are able to vote in that.
Yeah, I don't think it needs any further clarification because we've already established that the mayor is part of the council. And the only thing but taking your circular argument, you could go a step further and say, well, then as a member, it being that we're selecting of the membership of the council, that the mayor conceivably could allege that I can also be council president.
Except that I think we have it elsewhere that you.
Yeah, I think so too.
Right.
That's why I think that the
Okay.
circular argument kind
Yeah.
of ends there. So I think we're good where
No,
we're
you're
at.
probably right.
So would it help you at all if it said the mayor and the council shall elect from its membership?
I would, if there was to be any change, I would say that the mayor and council shall elect from among the councilors
Yeah,
a
because
council president.
if we were to do what Jeff just suggested, that makes it inclusive, which then would make the mayor exclusive from everything else unless we also specified the mayor there. And so I think we run into danger by
Yeah, sure.
having inclusive or exclusive
It's probably best. to leave it alone.
terminology.
Okay, we're gonna leave it alone. Is that the consensus? Yes?
Yep.
Okay.
Okay, moving on to chapter 6, section 6.1. So if you'll recall, the committee had recommended to add the deputy city manager role as a signatory for checks, but then Vice Chair Jarvis had a question about the fact that the deputy city manager is not referenced anywhere else in the charter, and should it be added to section 2.3 or 2.4? Section 2.3 states that the city manager shall appoint a treasurer/finance director, a chief of police, and such other officers and employees of the city as the council deems necessary, et cetera, et cetera. So I don't know if there's a desire for that. My comment back to Vice Chair Jarvis is that my role didn't exist before me and may not exist after me, and I don't know if there's a desire to force the appointment of my role on future city managers. I don't know that that's.
Yeah, and the remainder of my argument on that was when Cecily and I were kind of going back and forth on it, is that it's the only time that we reference the deputy city manager, and we have established in the charter that the deputy city manager shall be signatory, able to be signatory to checks. But if we don't, if the city council were to elect to dissolve the deputy city manager, we now have left something out there where somebody can sign checks and that person doesn't exist. So suddenly we're back to 3. And the reason that we added deputy manager as being signatory was to have that 4th person and another person on staff that was able to sign checks.
Well, and correct me if I'm wrong, but this is mostly a problem because we now have a contract finance director. Whereas before
Right.
we had somebody on site and this is physically signing things. And so I share the concern that we don't know if we will have or do we want to bind the council's hands to make sure they have a deputy city manager in perpetuity until this is changed. One option, I suppose, is if you want to stick with the previously in the charter, it just said city treasurer. It didn't use the term finance director. And you can, in my mind, you could appoint a contract finance director, but the city manager could also appoint any staff member as ex officio treasurer or something like that, or, have somebody designated as that role.
But if we do that, we then should go back and remove that as a provision, unless where that we added that as a provision, we put a parenthetical,
Yeah.
if any,
Yeah.
so that, or if one exists.
It's proving to be an operational question, I think, of what is going to fit city operations for as long in the future as possible. And I'm not sure I have a super good answer.
So I still think that we need to do one or the other. Either delete where we added her as that rather than her, because that's personalizing. It's not Cecily. It is deputy city
DCM.
manager. We either delete our addition of that in the charter because there is no reference with it anywhere else in the world. And then, 10 years down the road, if nobody notices it, it's going to be, wait a minute, where did this come from? Why don't we have this position? We've got it referred to in the and so we either codify it or we come up with another person as being signatory, as you suggested, as appointed by the city manager or something like that, in order to make sure we have that fourth person without putting ourselves in a situation where we've identified a position that may or may not exist.
What if you put council president in there? Because the council president already needs to step in for the mayor.
We already have. I
Yeah,
think
we
that's-
already have
that's
that.
one of- Yeah, that's one.
Effectively, yes, if the mayor's not available, we go
Yeah, that's one of the four already,
Yeah,
Okay.
because we'd only had
Well,
three.
so,
So we do have,
We have three. We have city manager,
Yeah.
we have mayor, and we have council president or pro
Pro
tem,
tem.
whatever it is right now. And what we added earlier on was a fourth person because of staff concerns about having that fourth person.
Yeah.
So if we are going to identify it, we should identify it as someone that is actually included in the charter. And if we're not going to include deputy city manager in the charter as an appointed position, then we shouldn't have deputy city manager as being signatory to the checks.
Does that bind the hands of the functioning of our organization? Are you signing checks on a regular basis as needed? Because the way we're structured right now. I think that we need to be careful and that we can create language as necessary to fit our needs. I don't think we should just discount that ability. But I don't think that we should have staff that are not directly related to the finance director position or the management of a deputy or city manager signing anything like that. I'm really, really concerned about that.
I kind of agree with that. I do believe that we're going to change wording. I really think that it should be worded about the city manager and the mayor first, because they're overseeing it. I know the mayor checks every single check before she signs it. I've had the luxury of signing checks one time, but and then we even had the new registry. So I think we're going to change wording. I think that we need to put some structure in there. So we don't appoint somebody that can just randomly sign checks behind the mayor's back, if that makes sense.
so there are the rules of the banks that you have to comply with as well. The banks aren't just going to allow any signature anytime. You have to go through the whole signing cards and everything. It's a pain in the butt. And so that's kind of one of the guardrails here, is that this isn't something that can be changed willy-nilly. You have to go through a process to be able to change it.
They can also make an electronic payment. They don't even have to have a check.
True. So one, I guess a couple of options. One, I still like the idea of perhaps just going back to the word treasurer, and that gives the city manager the opportunity to appoint any other staff member as treasurer in addition to their existing duties. You could also add the term in there, city manager or his or her
Designate, yeah.
and that would give an opportunity for some other person to be designated by the city manager. And the worry about that would be, well, you've just given the city manager the authority to designate whoever he wants to be able to sign checks. Well, keep in mind, of course, you're going to have to go through that check signing process for every, so it's, the city manager naturally isn't going to want to change that constantly. It's going to be, a good long chunk of time. So, I mean, it's an option.
I think the check and balance is the city manager's obligation to track who's doing checks and to report to the council if something is wrong. But I will tell you that over the years, we've had many, many times where the pro tem acted in the mayor's position for prolonged through the rest of their terms. It's happened many times because of health and different things that occur. So that position definitely needs to be able to sign checks in the event that our mayor is unable to finish their term. I think we need to revisit this one a little bit, that the city manager and or deputy city manager, however that works, we need to figure out how to work that in. Because I don't see long-term, as our city grows, we potentially could have a deputy city manager again. I don't like being obligated to have that position because finances go up and down. But I'm very uncomfortable about having any other staff that's not directly obligated to manage our finances, or to manage this entity, having that power to do that, because I think we're getting into the weeds.
I like the idea of the treasurer term coming back and then city manager could appoint, saying a short term, like the deputy city manager is that person. Since we currently don't have one, it would appear. And then if the deputy city manager position goes away, city manager can still appoint someone in leadership to take on that role for that purpose. I think kind of would.
Any other discussion on the treasurer?
So we would just be looking at removing the deputy city manager title from that paragraph and separating treasurer from financial director.
So then that would beg the question in section 2.3, will the city manager be obligated to appoint a treasurer and a finance director? Because right now they're combined as a single. Or are we removing,
I think you'd remove the finance director portion of it.
so we're no longer required to have a finance director?
Which is not good.
Well, let's keep in mind the treasurer in the previous charter was essentially the same thing as the finance director. What I liken it to is currently the city manager is the city manager and the ex officio city recorder. We don't have a separate city recorder. We just have that designation that has been tacked on to the city manager. I guess I'm seeing the possibility of a designation of treasurer that if you have an in-house finance director, that person is also, you could just have the city manager could sign a document saying, I appoint the finance director to be the treasurer.
Yeah, and I'm not disputing that. I'm asking because our language joins them. If we're taking the treasurer function out, but we want to maintain that the treasurer can be a check signer, we need to address in 2.3 if both are still obligatory appointments or not.
Well, right now we have it's obligatory for us to have a treasurer.
Correct.
But
that's what I'm asking the committee is, do you want to keep a mandatory treasurer and a mandatory finance director? Just because I have to change the language in 2.3 if this is the direction.
If I may, I propose that we leave, really what we did there is we clarified, because of in the past that we had appointment of a treasurer, but we don't actually have a treasurer. And we added the word finance director to clarify that, the treasurer is the finance director essentially. And then we added deputy city manager in order to get that fourth signatory. And so if you actually look at the language the way we have it right now, we've got the mayor, but we also have the president of the council that would act in mayor's stead and sign it. So what we could do is put the mayor or designee, city manager or designee, and the treasurer / finance director. And that would cover all of those concerns, including the one of establishing a position as signatory that doesn't exist in the charter.
So if you have mayor or designee, I guess we're assuming that the city manager would designate another staff member and not just any random member of the public. If you put mayor or designee, the mayor doesn't supervise anybody. You could potentially have a planning commissioner or Joe Q Public.
Okay, well, then what we could do is,
So you could have mayor or council president.
Yeah.
yeah, mayor or council president parenthetically, and then city manager or designee. And I don't think that there's a danger of him, the city manager appointing me, for example, to sign checks, because the city manager's job is contingent on being, making the city council happy. And so I don't think that we have as much a problem with that potential as we would. So I make a motion that we delete deputy city manager in that final sentence, that following the mayor, and then parenthetically, or council president, and the city manager, and then parenthetically, or designee, and the treasurer finance director.
So do you want parentheses in there?
Parentheses on the or designee and or council president, because what we're trying to designate there is that they're signing in place of the mayor, and
Yeah.
the designee for the city manager is signing in place of the city manager, not in addition to.
Sure.
We have a second.
Second, where is this at exactly?
At the end of
6.1.
chapter
6.1.
6, section 1, 6.1 in the new, on the bottom of, or top of page 6, middle of page 6.
Okay.
Okay, so we're in discussion.
Could you read that back?
So all physical checks issued by the city shall be signed by any two of the four following: the mayor, parentheses, or council president, the city manager, parentheses, or designee, and the treasurer/finance director.
Currently, we do have a finance director.
We do.
And that probably should now say 2 of the 3. We should go back to the 2 of the 3.
I'm sorry, it says any two of the following. I read the
Yeah,
strikeout.
okay.
The four
right.
has been
Yeah.
struck out.
2 of the, yeah.
Good.
No more discussion? Vote.
All those in favor say aye.
Aye.
Any opposed? Okay.
Can I ask about 5, 6? I see there was a highlighted section there we kind of skipped over.
Oh, yes, sorry, thank you.
Clarifying.
That was just another one of my questions. There was the change was to make sure that there was a maximum of 5 minutes given to address the council. Is there a floor to this? If you feel strongly about making sure things don't go further than a certain amount, do you want to give? people
Right,
at
and that was
least a
something
certain
that I
amount
was
of time?
looking at, where it says a minimum of, and trying to figure out a way to clarify that it is, that is the floor. That
Oh, you want 5 minutes to be the floor?
I want it not to be denied. I don't want the mayor or anybody else to be able to say, well, we got a lot of people who want to talk today, so you got 1 minute. I mean, the whole idea is being able to express an entire thought, which
Okay.
is hard to do with the time limits that exist right now.
So in that case, we don't want a maximum, we want a minimum.
Yeah.
Well,
Or
No,
we all
That's what I'm saying.
No.
It shall not be denied at least 5 minutes, or it shall not be denied the maximum of 5 minutes. If we were to include that establishes that you may speak up to 5 minutes. If you're done after a minute, you're done after a minute.
Okay.
so could
So
it just say
the
that the
problem
member of
is-
the public has the floor for 5 minutes
Oh,
for a
okay.
period of 5 minutes?
So we have 50 people in here and we're right now using 3 minutes. Because we have to be able to get done before midnight. And so right now, customarily, we're doing 3 minutes unless the mayor gives them extra time. Okay?
And we had
But-
that
I've never
discussion.
seen it where they've cut somebody down to a minute. That would be incredibly rude. And
I've seen it 2 minutes.
Have you?
Yes, I
Yeah.
have. You've got a lot of people that want, it was your husband. We've got a lot of people in here today, so we're going to restrict it to 2 minutes. And subsequent mayor did the same thing during a public hearing. We've got a lot of people that want to talk. We're going to keep it to 2 minutes. And that is not, if you come in with documents and you want to express a full thought. If you've ever sat on that side and wanted to express an entire thought, 3 minutes goes by awfully fast.
Yeah, and I will say too, because sitting on the planning commission and giving people the 3 to 5 minutes or whatever it is different sitting up here. I have been in that seat too. And even after being up here, sitting in that seat, you are a little shaken and things are, you don't want to say something wrong. You don't want to forget something. So having that little bit of extra time to compose
And that is,
yourself.
and I second that.
Yeah.
Because, I've done public speaking for years and years and years, but when I know I'm up against the clock,
Mhm.
it's like a timed test. And so it's easy to lose your train of thought.
So Vice Chair Jarvis, can you restate your proposed modification?
I'm not sure how to propose that, but what the idea was that they shall be allowed,
A minimum of 5 minutes. is
uh,
what you're asking
it
for.
it shall be,
No,
no, not a
no.
minimum, because then someone could argue that because I have that minimum, that I'm going to go on for 6 and you just shut me down when,
What I'm saying is if you put minimum in here, that means they're allowed a minimum of 5 minutes.
Okay,
That
shall-
they can, or I guess you could say they're shall allow
allowed to
each-
speak up to
up
5.
to 5 minutes.
Yeah, up to 5 minutes unless extended by the chair, and that would cover everything. That way it establishes that you're not going to be cut off in less than 5 minutes, but you may be cut off at 5.
Or you could say no less than 5 minutes, which it makes it a little bit stronger on on a restriction on the mayor's part.
Shall be allowed to speak no less than 5 minutes. Yeah, you look at me, I'm expanding it already. Shall be allowed to speak no less than 5 minutes.
Up to no less than 5. I want that.
Mm,
Well, you can put them both, I suppose.
Yeah.
just stating that they have the floor for 5 minutes.
Do
For up
remember,
to 5 minutes.
times 6 people.
Yep, I've been
Oh, I'm aware.
been on both sides of it.
It's a little
Yeah,
weird.
well, I've sat
Yeah.
in that chair for forest hearings and all kinds of things. And I'm going to tell you that there comes a time that people are reiterating the same thing and it becomes kind of abusive. And I was angry and upset about stuff going on with the timber crises. I know I'm
I,
a Nazi, but at the same time, these people, they're not getting paid to be here. And they go on to midnight and they can't do their business. And I'm concerned about that. I don't want to be mean. but
I chaired
I'm
meetings for over 20 years. We never had a meeting, except for maybe 3 times in all those years, that ended in the constitutional 2 hours. They were always extended because I firmly believed in giving people the floor and letting them express themselves. And if we had to be there for 4 hours or 6 hours, we were there for 4 hours or 6 hours. But my membership felt included, and we had very little difficulty getting what we needed when we needed it because we permitted people the right to speak.
Okay, so I think I'm still not clear on the language.
Yeah, where we were at is that the intent of this was that people could speak, and I will ask Blair for the shortest, best language that we can use, where that they shall not be denied less
He
than
did.
5
He
minutes.
gave us minimum. Minimum 5
Yeah.
minutes was
Less
his
than
best
5,
language.
shall not be denied less than 5 minutes. would work.
Have
Uh,
a period up to 5 minutes.
Yeah.
Could you say no more or no less than 5 minutes?
No, because then they can't extend. If if
That's
the
true.
council really wants to hear what you've got to say, then they don't even have the right to expand it.
Well, you
Maybe
still
you
got that
could say
best
that
part.
the mayor or chairperson may not restrict an
Less-
individual's comment to
Less than
less
five
than
minutes.
5 minutes.
That works.
The other matter is is registered in the original charter? Or is that something that was added?
That's probably
That
from
shall
the
allow
rules.
each individual registered.
Assuming, meaning signed in.
Well, right, but the charter itself doesn't actually
No.
address that.
Section 5.6 is new, if I recall correctly,
Okay.
because we didn't address public comment in the charter. This is wanting to enshrine public comment rules
Yeah.
outside of
Mhm.
council
Yeah.
rules.
I guess that's what that term registered isn't mentioned anywhere else in the charter. And so anybody looking in at this is going to be looking for guidance on what registered means. And so essentially by including it in there, you're basically, without any definition, it's going to have to go into council rules on what that means. And if you're okay with that, that's fine. But
Could we change it for each individual recognized under public comment, the public comment period of the meeting?
So I do want, again, I'd like to caution. I've sat out there when our mayor and councilors were being called baby killers and things like that. And officers had to be on the premises for their safety. And to open a floodgate without the ability to stop it is concerning to me. Like I said, we've had very unhinged people attend our meetings and say very mean, belligerent, nasty things. That was very harmful. And you're not putting a cap or a mechanism on that. Okay. And so, yeah, I just be careful.
Can the chairperson, like if we have a hot topic and we have 6 people that want to speak about the same thing that's on their comment card, can we strike those?
So technically under the rules, if you are here and someone ahead of you says what you came to say, you're supposed to just say, I agree with them. That never actually happens, but that is technically in our rules for public comment. Well, and now that we're talking through this, if we reference public comment directly, then what would stop me from putting something under a public hearing and then we set the public hearing rules at 2 minutes? Because it's no longer public comment, it's public hearing, which is different.
except that that's an area where you're going to get more challenges and lawsuits over.
Right. But I'm thinking now it's not as,
But we've already had that before, where the question came up, or I brought up a question at a city council meeting, and it was either you or Blair, I think it was Blair actually, who then said, well, the rules for public hearing are different than they are for public
well,
comment.
for individual items versus the public
Right,
comment
right.
period. Yeah, I do recall that. And again, that's where the council rules had a conflict within themselves procedurally.
So this would technically be, if you specify the public comment period, that's the portion of the meeting that is available for people who are going to talk about something that's not on the agenda. The other items, I think, can be, you can, like, if I show up to a meeting and there's an agenda item for whatever, issue A, and I put on my card, I want to speak on issue A, the mayor is likely to call on me when that issue is brought up and not during the public comment period. And so that comment wouldn't fall under this paragraph because it's not during the public comment period, it's during that agenda item.
So to get around that, you could change the language to specify that anyone
Any public
recognized to speak during a city council meeting shall be afforded no less than 5 minutes, or however we're going to settle on that language.
And
Shall not
I
be
make a
restricted.
motion that you alter it like that.
I would say shall not be restricted to less than 5 minutes.
Right.
Is the language I would choose. Because that gives the person the option to restrict themselves and speak less.
Are we still comfortable with titling the section public comment?
Thought you said you were gonna.
Well, we probably should be the public comments at any regular city council meeting or non-public hearing.
But the intent is to be anytime they're talking during a council meeting, whether it's during public comments.
Okay, so we have a motion.
I'll second that.
Okay.
Can you read what it says now? Because I'm hazy on it.
Yeah, I am as well. Okay. Okay. Um, okay, let's workshop this. Those recognized to speak during any regular city council meeting shall be allowed no less than 5 minutes to address the city council unless additional time is granted at the discretion of the chairperson.
Yes, that meets what I was trying to say.
And Committee Member Reynolds just want to clarify with seconding that. Okay. Any other discussion?
No discussion.
And then, I'm sorry, and then also suggested to modify the section title to public comments at regular city council meetings.
Well, just comments, period, because we've already identified it as regular
Okay.
city council meetings in the next sentence.
Okay, so what do you want the title to be? Sorry,
Public comments?
just public comments?
Public comments.
Perfect. Okay. Okay. So any other discussion?
No.
Okay. All those in favor say aye.
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 Any opposed? Okay.
I was really hesitant on it as well, but I'll let it go.
Council and take it all out.
Okay, so then
So 6-2.
6-2.
6-2.
Vice Chair Jarvis, I think you had another comment on 6-1, did you not?
I suggest we delete the words of the council, and you did do that.
I did. Okay.
Yes.
Okay. Great. So then, yes, 6-2, City Attorney Larson had a comment on the sum of the bond of the city manager.
It seems that with inflation, this has become a if there was something that the city manager did that would violate this bond, $10,000 is not going to be enough to. Sorry, 10,000 isn't going to be enough if the city manager was to, I don't know, malfeasance or whatever. That's a drop in the bucket compared to what damage could be done. And so in lieu of an actual number, my recommendation would be just to state a bond in such amount and with such surety as may be approved by the council, which basically gives some flexibility with that number to change in the future as necessary.
So moved what he said.
Second.
Any other discussion? All those in favor say aye.
Aye.
Any opposed? And moving on to page 8. City Attorney Larson in the section regarding the manager pro tem had a suggestion to modify the language.
It's just in order to simplify it, rather than having specified terms, just giving an overall, no more than 18 months as authorized by 4 affirmative council votes.
But if I do recall the discussion, I think the intent was to force a review of the pro tem every 6. So
Okay.
this would
And
eliminate
perhaps I'm
that.
forgetting that. If that's the case, then certainly I retract, but I was thinking maximum flexibility.
That's up to the committee.
It's fine the way it is.
Yeah, I like it the way it is.
All right, and then as City Attorney Larson mentioned earlier, he had found some free speech issues. So you'll see in this comment for interference in administration, he's recommending removal, and then some language to insert in its place.
Yeah, and I'm sorry for the small text on my comment, but that's where the meat of it is. So essentially what I'm suggesting is that F would be removed and replaced with 2 different sections. F would say appointments and removals. Neither the city council nor any of its members nor the mayor shall in any manner control or demand the appointment or removal of any city administrative officer or employee whom the city manager or any subordinate of the city manager is empowered to appoint. But the council may express its views and fully and freely discuss with the city manager anything pertaining to appointment and removal of such officers and employees. And then G would be interference with administration. The council or its members shall deal with city officers and employees who are subject to the direction and supervision of the city manager solely through the city manager, and neither the council nor its members shall give orders to any such officer or employee, either publicly or privately. I believe that this will better comply with case law and the free speech issues that Corvallis has experienced, and it kind of clarifies what is going on. To give a little bit more, elaborate a little bit more on that one, a counselor had voiced in a public meeting that a specific position was vacant and needed to be filled. And in my opinion, it was a bit extreme. The city manager and the city attorney took that comment and shoehorned it into the interference with administration paragraph, which is identical to what we have in our charter, and used that as an effort to remove that counselor from office. In my reading of it, it was a bit of an extreme move, but the rest of the council agreed and voted to remove the person. I have to think that there was some personality conflicts in general that added that, but none of that was in the record. However, it went to federal court and it was reviewed on First Amendment grounds. And essentially the meat of this interference in administration paragraph was tossed out as unconstitutional. And I believe it was unconstitutional flat out, not as applied. And so it's just very concerning having this in here, and we want to make sure we have some guardrails. I understand the desire to keep the council from getting involved in operations, but we have to make sure that stray comments aren't taken as such. I think this is much more, it's not this, if you make a comment in a public meeting, you shouldn't really be penalized for that when that's made in the public. Your opinion about that there should be such a position, that's fine. I think the intent also is to keep there from being pressure to appoint a specific person. I think with the ethics rules that are in place in this, I think that's pretty well covered as well. So those are my recommendations. If you have any questions, I'm happy to discuss it further.
I think it's great. I move we adopt as Blair proposes.
I second that.
Any discussion?
I think it's wise.
Move to a vote.
All those in favor?
Aye.
Any opposed? Okay. And I think just down to minor things, section 7.3, Blair, I believe you just removed publication thereof because it was, oh,
Hold
go
on,
ahead.
There's one more, that paragraph, that interference in administration paragraph, as it was originally in there, the last sentence says, neither the manager nor any person in the employee of the city shall take any part in securing or shall contribute any money toward the nomination or election of any candidate for municipal office. That's like a completely separate topic
Yeah.
than that interference in administration. And I think it still has merit. I don't have any concerns with it. I think it just needs to be its own little subsection and move out.
You're talking about G or F?
In as it's written here in F,
Right,
that very
right.
last sentence that starts with the word neither.
Yeah,
I think that's likely worth retaining. It just doesn't belong in the same category as those other things and should be its own. So the way I see it is you could have, you know, what we just talked about was a new section F followed by a new section G. And then
renumbered
then there
as,
would be this other section, that neither would be another section. It would be H, and then the existing G would become I.
right, right. So I make a motion that we do adopt new section H. That would E, F, G, yeah, H, that would include the final sentence of what we deleted from F.
Second.
Any discussion? No.
All those in favor?
Hi.
Any opposed? And just any suggestion on what to title that section, city attorney?
Blair's chapter.
It's a Blair's section. Blair's Law. No, I would probably title it, I don't know. Maybe,
Prohibited actions? Well, that wouldn't hold true for F. That would work for G and H.
maybe financial support of municipal office candidates. That's kind of the.
Is it specific to just financial though? Because when I read
So,
securing, I,
contribute any money toward. Yeah, it's securing or contributing money toward the nomination or election.
oh, I guess I read it as securing the nomination or election. I read those as,
Yeah, securing it. And so maybe,
Oh, yeah.
maybe it should be its
sure.
own subsection
So you could
or
call it
its own section.
participation in elections.
or interference
Election interference.
in nomination or election.
Is it I don't know that I would call it interference.
Okay.
Because, I mean, this is something that.
Canoodling. Election canoodling.
Should it be its own chapter?
I would just say support of support of municipal office candidates. Because that could be financial support, it could be vocal support, it could be whatever. And I think that's all in that idea.
Okay, I'm not hearing any discussion, so I'm gonna move on. Page 9, again, section 7.3.
Question.
Oh, I'm sorry.
Could it just be called election neutrality?
Yeah, you could do it that.
That works.
That could be,
Yeah.
that's probably simpler and wiser.
Thank you.
I liked
All
canoodling.
right, adopted.
Canoodling. We'd have to define the term then.
How would you define the term?
I don't know. Co-noodling.
Okay, so section 7.3, City Attorney Larson, I think you just struck through publication thereof because we struck the
Yeah.
publication requirements, correct?
Yeah,
Okay,
yeah.
so if there's any discussion on that, we can have it, but otherwise I think consensus is fine.
Yep.
And then there was a very minor language correction in 8.3.
I only found that one because Robert bugged me about it.
Thank you, Robert. Okay. Anything else we want to discuss in this charter before we close this portion of the agenda for hopefully the last time?
I think we did an amazing job.
I agree. Thank you all very much. So in that case, we'll move on to the final item, and it is up to the committee if you want to have a discussion on this or not. But essentially, as you know, there are different ways that these proposed changes can be packaged for the ballot. And as you also know, council will have the opportunity to modify anything that you recommend. But we were just wondering if you all have a recommendation for how you think council should place these items on the ballot. If it should go chapter by chapter, if you want to throw it all as one measure, if you think we need to figure out how to break it out differently from that. We were just wondering if there's any opinion there.
The danger that you run into is if you have it all in one, people don't read the whole thing and you're just going to have it, oh, change. Okay. Yes. Or that's too much. No.
Or I see one thing I don't like, so to heck with the whole thing.
Exactly. But then if you break it up, that makes it so that you could have some portions definitely that are going to pass because they're no brainers and separate the controversial things into their own section. It makes it more likely that you get some of the desired changes. But you also, with something like this, you could overwhelm the public with a whole bunch of questions, which also has its dangers. So
are you
I don't think there's any good answer to this.
are you recommending like we do it in sections, like,
I don't think
chapters 1 through 5, or are you looking at saying, we're going to adopt updated language? That's one version, or adding, changing who signs checks. That's another section. I mean, how?
I think those there's lots of different ways you could do it. You could do it by chapter. You could do it by topic. You could do it in order of priority of what's most important to you. For example, I think everybody felt, I know at least some of you felt really strongly about the ethics portion, and that's a brand new portion. And so that could be considered separately on its own, that kind of thing. So it's there's a lot of different possibilities. I guess my main question is, are you concerned about portions of this, assuming the council puts its blessing on the entire thing
As it
and
stands.
they're all as it stands as of the end of this meeting, which are there any of the portions of this that you think the public is not likely to support, or you think that, are you worried about asking too big of a question and having people not vote for it just because it was too big to read?
So
what are your concerns? I would say.
and I pose this. I mean, I don't know what kind of dealings you've had with stuff like this in the past, whether you or any other staff, based on the amount of changes and the size of our charter. I mean, what would you think about for on the ballot? Would it be five sections or 10 sections? I mean, what makes sense? I mean, can we just title the whole thing, "Do you like donuts?" And they say yes, it
No.
passes.
No, legally we can't.
Legally, you can't. There are very specific. I mean, there's state law that governs how the ballot title is worded and created. So, if you decided to package this all in one question, which I believe you could do, there would be a condensed ballot title that is limited in how long it can be. That no doubt, probably I would be the one tasked with crafting it, would be trying to condense all of the changes into that and fit within the state requirements, which it's possible. It would be an exercise in brevity, definitely, but you could do it. And the question is, are people going to read that little ballot title, and are they going to be okay with all of the changes? And so, or are they going to, like Committee Member Jarvis said, are they going to see one thing they don't like and not vote for it because of that? And then you run the risk of the whole thing not passing. So that's the main concern, is that if there's something in here that you think is going to deep six the whole thing, then you may want to separate that out and have it be a separate question. Then again, you also have to be careful and not put all the negative things in one in one area. There has to be some
balance.
the law requires that there's some cohesive reason why those are grouped together.
My only comment on that is that we could, look at it and look at all the things that we have come up with and try to break them down either by chapter or, because, but some of it bounces around too, to where we made what change in one chapter to be consistent with a change that we made in another chapter. And so if we were going to break it down like that, it would have to be the things that are relevant to each other that you would want on a same ballot. And the bottom line is we could take an hour or 2 hours to come up with our own list, but ultimately 90% of what we have recommended here may be defeated. And so anything that we suggest here would potentially also become moot if the things that we, unless we want to, we could sit here and do that if we want to be really confident that every darn thing that we came up with is going to be embraced and like, why didn't we think of this ourselves? But we know that's not going to happen. It's going to be debated amongst the city council members first and foremost. And then I think that's when it's up to you and staff to pretty much decide, how best to package this for the voters.
Well, and to do that job, I think we would like to know, at least speaking for myself, at least, I think Cecily probably agrees. We'd like to know what's most important to you, so that we can find find the configuration that's going to best achieve those goals.
I think we should just summarize it. If you send a ballot out,
Highlighting the updated
yeah, if
language.
it's got a
and-
front and back page, no one's gonna read it.
I agree with that.
I mean, even with ballot measures and stuff like that, they get long and it's like,
Well, so we are going to have to include all of that for the
Right.
vote. It is going to be,
but there's gonna be a summary though.
What'll probably, and what's probably going to be is there's going to be a ballot title. There's going to be I forgot the name
The
of it.
ballot
It's
summary.
The summary.
Yeah.
Mhm.
And those are going to have to, because the text obviously isn't going to fit in there, there's going to have to be some reference to where you can
Like
read
a web
that,
address or
where
something.
you get the whole thing. Yeah.
Yeah.
Either it's posted at City Hall and the police station and at the city website.
And I think by doing that, we increase the chances of people just saying, hell no. Because there's something hidden in there and I don't want to go find it.
Maybe.
then-
I think the majority of people don't care.
Yeah,
No,
I think
that's, that you've got, I think that's valid also. A lot
Yeah.
of people really don't care.
if you're
uh,
highlighting that,
but-
you're just updating the language.
But
and-
I don't think we want to do something that's going to make it difficult for people or perceive a perception of difficulty in finding what it is that we are recommending, because I think that I think that kind of defeats the purpose of everything that we've been doing here.
well, and keep in mind too, it doesn't all have to go on one ballot.
Oh, yeah, and that's good too. We
If
could
you wanted
piecemeal
to
it
do
out. Yeah.
Round 1 in May,
Yeah.
see how it goes. That's an option.
Preemptively, couldn't we just take sections prior to elections and have it published on social media and in the newspaper, sections by section, so that they're inoculated and they have had time to mull it over? Because I don't think that they're going to have a problem with the charter update.
So there are some rules though on who can do that. And I think that I'll have to refresh my memory on it. But if I remember correctly, in public meetings and when it comes to staff activities, we can't take any involvement in promoting.
We can
voting
provide the summaries.
We can
just
provide the
can't
summaries, we can
argue
provide the
vote for it.
information. But when it comes to the outreach to promote it among people, that's not something that I
Well,
don't think
public-
staff can do that.
Public education is not influence and opinion. It is just putting it out there in a manageable way so that people have an opportunity to review it, just like anything else.
Sure.
You don't have to have an opinion to make it accessible.
Yeah.
I think that's the key here is making it accessible so people have had an opportunity multiple ways to have seen it. So when they go into the ballot, I just don't think that they're going to have a problem with it because unless there's something with huge red flags, then we need to stop and look at it again ourselves.
And also, we put it out there for 30+ days to get public response on any of this, and we got,
Mm-hmm.
so,
And we are planning to bring all of this to a city council work session on, is it the 28th of October?
I don't remember.
Whatever the fourth Tuesday is. We are planning to do that. You're all more than welcome to come. We'll probably recommend that any members be recognized, even though it's a work session. And as part of that, we are planning to put together a summary of all the changes. Just high level, easy language. This is what we did. And I think the same thing
yeah,
will go out publicly just to make it digestible.
yeah.
Yeah, I think that'll help. That'll help a lot, I think.
So it sounds like the general consensus is that you'd like to see it all in one ballot measure.
That makes the most sense to me.
Keep it simple.
All right.
Well, and keep in mind too, whenever we get to the point of referring it to the ballot, that has to go to a public vote. So if you change your mind or have thoughts on that, whenever that does end up on a city council agenda, you're more than welcome to come with your hopefully 5 minutes.
If it's a really big meeting, it might be only 2.
Yeah. So, but we would certainly want to hear from you when we get to that point, if you have thoughts when we get to the referral portion.
Well, I would like to thank everybody for coming and putting out such a great effort for this committee. It's one of the best committees that I've been on. So I appreciate you guys. And
if I could just get a final motion, second, and a vote to forward all of these changes as a package to city council for consideration.
So moved.
Second.
All those in favor?
Aye.
All right. Good job.
okay, we're going to adjourn at 7:17 or 15.
May I just say you've all been a pleasure to work with. Thank you very much for serving and